Hi friends, today we are discussing on marine insurance. In that specifically we are discussing on warranties and disclosure. In this session on that particular topic, warranties and disclosure, for the convenience of you, I am dividing into 7 headings. First one, what is the meaning of warranty? Then form of warranty. Next, difference between warranty and representation. Fourth one, the effect of breach of warranty. Fifth one, character of warranty. Sixth one, kinds of warranty. And lastly, waiver of breach of warranty. So we are discussing all these aspects in these sessions. Let us start with meaning of warranty. What do you mean by warranty? Is it the same meaning what is in the Sale of Goods Act, or is it a different meaning? So let us look into the meaning of warranty under Marine Insurance Act, or you may say even in other insurance contracts. The term warranty is used in the law of insurance in a different sense from that in which it is used in other branches of law like Sale of Goods Act. So the definition of warranty under insurance law is different from the definitions given under different legislations, that is also specifically Sale of Goods Act, warranty. So here warranty here may be defined as stipulation or engagement by a party insured that certain matters relating to the subject matter affecting risk exist or shall exist or have been done or shall be done. So this is the wordings of warranty under insurance law. In one of the famous cases, Thomson versus Weems, Lord Blackburn observed that in all policies of marine insurance, any statement of fact bearing upon the risk introduced into the policy is construed as a warranty, and compliance with that warranty is a condition precedent to the attaching of the risk. It means whatever policyholder stated in the proposal form, on that basis the risk is assessed, premium is fixed. So if that particular fact or that particular thing is changed, then you may call it as a breach of warranty. We will discuss in detail in further slides. Let us look into warranty comes into existence in one of the following ways, that is discussed in the section 35 of Marine Insurance Act 1963. First one, where the assured undertakes that some particular thing shall or shall not be done. Here policyholder undertakes that some particular thing shall or shall not be done. That's the first point. Second one, where he undertakes that some condition shall be fulfilled. Here policyholder undertakes that some condition shall be fulfilled. And third point, where he affirms or negatives the existence of a particular state of facts. So these are three ways through which warranty comes into existence in insurance contract. So whatever he says in the contract in following 3 ways, he has to follow that. He has to follow mandatorily. There is no alternative ways for the policyholder other than strictly following that particular thing. The term warranty is used in the law of insurance and may be express or implied, especially even in insurance law. Warranty may be expressed or implied. Implied specifically in insurance, marine insurance, that is a very important thing. Seaworthiness of the ship is a implied warranty under marine insurance contract. Other than that, it should be expressed in the contract between the policyholder and insurance company. The warranty as defined is a condition which must be exactly and strictly complied with, whether it is material to the risk or not. So, under insurance contract, warranty may be defined as a condition which is mandatory, which must be exactly and strictly complied by the policyholder, whether it is a material to the risk or not. So, that is very important aspect. If it is not complied with, assume that if policyholder not complied with, then what happens? Subject to the terms of the contract, the insurer is discharged from liability from the date of breach of warranty, but without prejudice to the rights of the insured before that date. It means the date on which policyholder breached the warranty, from that date, from that time, the insurance company discharged from the liability. So, that is the point. That is why warranty is very important aspect in insurance law. In the law of insurance, the term warranty is used to denote, first thing, a condition or a condition precedent for the liability of the insurance company, or second one, as an exception from liability of the insurance company, third one, as a limitation on the general words used in the policy. So, these are the aspects the policyholder always should concentrate and act accordingly. In two cases, very important cases, first one, provincial insurance versus Morgan. In this case, court observed that in policies of insurance, the term warranty has been used interchangeably with condition. So, sometimes in insurance law, the warranty interchangeably used with another word condition. So, that is said in provincial insurance versus Morgan. In another case, Lakshmi Insurance Company versus BB Padmavati. In this case, it has been held that the warranty is a statement or representation forming the basis of the contract, on the truth or false of which the validity of the entire contract depends. So, in this case, what court held that warranty is a statement or representation which forms the basis of the contract, on the truth or false of which the validity of the entire contract depends. Especially in every insurance contracts, it starts with the filling of the proposal form. When policyholder fills the proposal form, he has to answer to all the questions asked in the proposal form. At the end of the proposal form, there is a verification clause. So that clearly says that whatever said in the proposal form, those facts are the basis of the contract. So that's why always we should be very careful that while filling the proposal form, always we should write the truth, so that the insurance company not able to escape from liability. Coming to the second point, form of warranty. A warranty is generally in writing and is usually inserted in the policy. It may be inserted at any place in the margin or footnote, or even on the back of the policy. But if it is written on the back of the policy, the fact should be referred to be the face of the policy. So that is important, you have to mention. It may be made in another document which may be incorporated in the policy by specific reference in the policy. Neither any particular form nor any technical words are necessary, so long as the intention to stipulate a warranty is clear. So what we should understand is the warranty may be mentioned in the margin or footnote or backside of the policy, or in another document you can mention about the warranty, but you should mention that particular document details in the main document. So that is the important thing. Even an answer in the proposal form, whether incorporated in the policy or not, will have the effect of warranty if it is clear, either from the terms of the form or otherwise, that it was the basis on which the parties contracted. In marine insurance, warranties may be implied, but in other types of insurance, warranties are expressly provided. So only in marine insurance we will come across implied warranties, that is the seaworthiness of the ship. But rest of the other things within marine insurance as well as the other insurance contracts, always warranties should be expressed in the policy. Next point we have to discuss is representations, that is discussed under section 22 of Marine Insurance Act 1963. During negotiations means before signing the proposal form or before contract is concluded, earlier position. So during negotiation, the proposer or his agent is likely to make representations with a view to introduce the insurer to accept the risk and to secure a policy at a lower premium, just as they may be conceal certain facts with the same end in view. So during the negotiation, lot of statements made by the policyholder to the insurer to motivate or to influence the insurer to accept the risk and issue the policy. The Act states that material representation must be true. The policyholder may be told lot of things ultimately for the insurance company material representations, whatever stated, should be true. So that is the basic concept of uberrima fide, utmost good faith. Both parties must disclose each other all material facts, and especially policyholder, he should disclose all the material facts about his product, goods, because it is impossible for the insurance company to know all those facts, because everything known to the policyholder. So that's why in representations, before contract is concluded, during negotiation, the policyholder has to disclose all material facts. If they were untrue, the insurer may avoid the contract. So that is the principle I said, utmost good faith. If policyholder is not following utmost good faith principle in filling the proposal form, if insurance company comes to know some of the material facts are false and the policyholder misrepresented to the insurance company, then at any time insurance company can avoid the contract. Therefore, the policyholder should express everything true facts in the proposal form. Examples for material representations. A representation that the ship was fully overhauled and strengthened by iron beams, means the ship is very strong because made up of iron beams. Giving an exaggerated value of a ship or cargo, giving an exaggerated value of ship or cargo. These are the material representations on which risk is assessed, premium is fixed by the insurance company. So that's why these facts are considered as a material representation, material facts. If these things are false, then at any time insurance company can cancel the contract. Next point is, what is the difference between representation and warranty? We are talking about two worlds, two concepts. What do you mean by representation and warranty? How it is different? Let us look into one by one distinction, difference. One side representation, another side warranty. Let us start with representation. Representation, it need not be inserted in the policy and it may be made orally or in writing. So that is representation. And in warranty, it should form part of the written contract in the policy, and so it must always be in writing. So always it must be in writing. Next point, next distinction, representation, it must be an inducing cause to enter into a contract, so it precedes the formation of the contract. And in case of warranty, it comes into existence only on the completion of the contract and never before. So that is very important distinction. Third one, representation, a substantial compliance with a stipulation would be sufficient. Substantial compliance of representation. Representation may be withdrawn or corrected before the contract is concluded. It may be altered, corrected before contract is concluded. For example, a representation that a ship carries 12 guns and 18 men is substantially correct if in fact she carries say 7 guns and 15 men. So, this is allowed because substantially compliance if it is in representation part, in negotiation part. Let us come to the warranty. While in the case of warranty, it must be proved to have been exactly correct or it must be literally fulfilled. Means substantially compliance will not be allowed if the same thing is in under the warranty. If it is in the warranty, it should be exactly correct, it must be literally fulfilled, means 100% compliance. Otherwise, it is a breach of warranty and insurance company gets a right to escape from liability, stating that you have breached the warranty. Fourth distinction, if it becomes false, it becomes a misrepresentation. In case of misrepresentation, it becomes a false, it becomes a misrepresentation, willful or innocent, as defined under sections 17, 18 of Insurance Indian Contract Act and the under section 19 of the Act. Contract becomes voidable if it is a misrepresentation. The insurer can avoid the contract on certain equities like return of the benefit like premium. In case of representation, if there is a misrepresentation, on that basis insurance company can avoid the contract by particularly on the equity principle return the benefit. But in case of warranty, if it is breached, it discharges the insurer absolutely without giving rise to any equity in favor of the assured in regard to the return of the premium. So, in case of breach of warranty, just insurance company liability ceases. There is no question of any equity principle applicable to this particular situation. So, you should be very careful when the particular thing is mentioned under warranty, you should fulfill 100%. Last distinction, that is the fifth distinction between representation and warranty, is when we take a representation, it should be complied with only when it is a material. But in case of warranty, whether it is material or not, it should be complied with. So, that is a mandatory thing in case of warranty. If you are not fulfilling that, then it is a breach of warranty, then insurance company escape from liability. So, these are 5 distinctions between representation and warranty. You should remember these distinctions. Thank you. Hi friends, in continuation of our earlier session, what we were discussing about the warranty stipulation. So, in this session we are continuing on the same topic. So, let us look into the cases in which they look into the warranty. In a CTN cash and carry versus general accident, in this case, an obligation on the assured to ensure that its cash chest was at all times attended to during business hours. described in the policy as a warranty was held to be a term description of the risk. On this finding, it was held that the insurers could deny their liability when cash was stolen when the chest was unattended. So, in this case, what court observed is specific warranty is not followed, and because of that breach of warranty, insurance company rejected the claim and even court upheld that because of breach of warranty. Looking into the whatever we have discussed, we can say that the summary, a stipulation or representation will not become a warranty for the mere reason that it is inserted in the contract. All warranties are stipulations, but all stipulations are not warranties. The difference between the two is analogous to the difference between a condition and warranty under Sale of Goods Act. So, if we thorough with that condition and warranty under Sale of Goods Act, so same way here we can say that conditions under Sale of Goods Act the same or equivalent the warranty under insurance law. The breach of warranty, whether material or immaterial, increasing or diminishing the risk intentionally or unintentionally, will always give rise to a right to the insurer to avoid the policy. Always it gives the right to the policy, insurance company avoid the policy because of the breach of warranty, whatever mentioned under the policy. It is a mere stipulation. The breach of it does not vitiate the policy and does not give rise to a right to the insurer to avoid the policy, but may give rise to a claim for compensation. If it is a mere stipulation, the breach of it does not vitiate the policy and does not give rise to a right to the insurer to avoid the policy, but may give rise to a claim for compensation. Coming to the next point, effect of breach of warranty. By making representations into warranties, insurers derive three advantages. First one, breach of warranty gives them an option and a right even to avoid the contract, whether the representation is material or not. While if it remains a mere representation, the insurer have not only to prove that the representation is false, but also further proves that it is material before they can exercise the right to avoid the contract. So, that is very important aspect. Burden is on the insurance company to prove that that particular fact is material fact. Even in cases where the insurer decides to avoid the contract on the ground of breach of warranty, he can merely repudiate his liability, but can still rely on the terms of the contract, like a clause providing for arbitration. while in the case of breach of representation, whether it amounts to misrepresentation or fraud, it renders the whole contract voidable, and if the insurer decides to avoid the contract, he should avoid it in toto, including the arbitration clause or any other clauses. When the representation becomes a part of the written contract by incorporation, oral evidence cannot be admitted to vary the terms of contract. It means a representation is covered under the written contract, and oral evidence of other things cannot be admitted to vary the terms mentioned under the contract. Next point is special characters of warranty. Let us look into one by one. So, first special character of warranty is materiality irrelevant. Second one, strict compliance necessary. Third one, the breach of warranty may not cause the loss. Fourth one, once a breach, always breach. So, let us look into one by one in detail to understand these statements. Let us start with materiality irrelevant. In order to avoid contract on the ground of falsity of a representation, the representation should be material to induce the consent. While in the case of warranty, the only fact to be proved to avoid the policy is that it is false. The fact whether it is a material or not is wholly irrelevant. It also does not matter whether the fact represented by the warranty is important or trivial. It means whatever stated under warranty, it should be strictly followed, fulfilled by the policy holder. So, that is the point. Second character, strict compliance is necessary, where insured is promised by the warranty must be strictly performed, and by deviation, however slight and irrelevant it may be, entitles the insurer to avoid the liability under the policy. Means whatever mentioned under warranty is strictly performed by the policy holder. Otherwise, the policy holder giving opportunity to the insurance company to avoid the policy and escape from the liability. Here, strict compliance is necessary, and a substantial compliance is not sufficient. This is a very important thing. Substantial compliance of the warranty is not sufficient, because the compliance with the warranty is independent of its effect on the risk. Therefore, strictly complete fulfillment of the warranty should be done by the policy holder. Next point, character, is the breach of warranty may not cause the loss. Due to breach of warranty, there may not be a loss. Even then, it gives right to the insurance company to avoid the contract. It is no defense for the assured that though he committed a breach of warranty, the breach has nothing to do with the occurrence of the loss or damage. The rule of proximate cause has no application in the case of breach of warranty, especially in marine insurance. Let us take an example of voyage policy. A ship moves from A port to B port in a particular path. If that ship deviates from the mentioned path in the policy, when it has deviated, nothing has happened. After some period, it has come back to the original path and it is moving. So, under this particular character of the warranty, that it should not deviate from the mentioned path under the contract without any valid reason. If it deviates from that moment itself, when ship deviates without any valid reasons, from that moment itself, insurance company's liability ceases. So it deviates and comes back to the original path. Afterwards, something has happened, loss has happened, the insurance company is not held liable. The policyholder, he cannot take a defense that that loss is occurred during normal path, not during the deviated path. But according to this particular principle, character, once it deviates, and under the policy, deviation without any valid reason is not allowed, that is a warranty. Then if they deviates, it's a breach of warranty. From that moment when it deviates, it's a breach of the warranty, and immediately insurance company ceases its liability. Whatever happens later, for that insurance company is not held liable. In a case Glean versus Lewis, a warranty is made that steam engines will not be used, that is the warranty. But subsequently, on an experimental basis, for a short time a steam engine was used and then withdrawn. Later, the loss was caused by fire, but still the insurer was held discharged by breach of warranty. In this case, warranty is ship should not use steam engines, that is the warranty. On experimental basis, the policyholder used the steam engine. When they use the steam engine, immediately the liability of the insurance company ceases. Even though later they withdrawn steam engine, even then any loss happens during the normal engine, insurance company is not held liable. So that is a very important aspect. Last character is once a breach, always a breach. It means if once a breach of warranty is committed, it discharges the insurer from liability, notwithstanding that the breach of warranty is remedied and complied with long before the loss. But in order to entitle the insurer to avoid the policy on the ground of breach of warranty, it must be proved that the breach has been committed during the factual subsistence of the policy. Earlier I have given an example of in case of the voyage policy, ship is deviated without any valid reason. So in those cases, once it deviates, from there itself the insurance company liability stops. Later, if ship comes back and loss occurs during the mentioned path, for that particular loss, insurance company is not held liable. That's why once a breach, always breach. So that is the statement under marine insurance. Coming to the next point, kinds of warranties. Many kinds. Let us start with one by one. Warranties as to present warranty. There are warranties relating to a fact or set of affairs warranted to exist at the time of the contract. These are sometimes called warranties as to the present only. A breach of such warranty has the same legal effect as fraudulent representation made by the assured. Before completion of the contract, and the insurers can avoid their liability under the contract. So this is warranties as to present warranties. Next one is in accident insurance. Questions like in the proposal form, are any explosives used in your business? That is the question. And answer is no. Means in a business, are you using explosives as a raw material or in any other purpose? The answer given by the policyholder is no. So here it was in one of the case, Benchamp versus National Mutual. It was held that it was a warranty as to the future. So if the future warranty is breached, means in future that particular warranty is breached, then it's a breach of warranty and insurance company is not held liable. Next kind is express warranty. A ship is warranted to sail from Bombay with 50 hands or upwards. She sails from Bombay with a crew of 45 only, but afterwards takes 8 more. The warranty is not exactly complied with, the insurer is not liable. So express warranty means under the contract it is clearly mentioned, when if a ship starts from Bombay port, 50 hands or upwards should be the crew, but they started from Bombay with 45 only. Later they took 8, but starting point they were 45, but under the contract warranty was 50. So they have not fulfilled strictly that 50 number. Hence, court said insurer is not held liable. Another very important character is, or you may say kind of warranty, is implied warranty. In a voyage policy on ship, there is an implied warranty that at the commencement of the voyage, the ship shall be seaworthy for the purpose of the particular adventure insured. So especially when voyage policy is taken or time policy is taken or mixed type of policy is taken, depending on the type of the voyage, that ship should have seaworthiness. Means safely it should reach to from one port to another port which is mentioned under the contract. So that is called seaworthiness. So seaworthiness of the ship is implied warranty under marine insurance contract. Next point is waiver of breach of warranty. A breach of warranty does not render the contract in the policy void, but only confers a right on the insurer to avoid the contract under the policy. So, it is left to the insurer either to claim this right or leave it. When the insurer decides not to exercise the right and allow the policy to be treated as a subsisting with the knowledge of the breach by the assured of warranty, he is said to have waived his right. The waiver must be express or implied, but it must be intentional. So, under this particular point, waiver of breach of warranty, it means policyholder breached the warranty and that information reached the insurance company, and insurance company knows that there is a breach of warranty by the policyholder. At any time, the insurance company can avoid the contract, come out from the contract, but if insurer feels that or decides not to exercise his right and allows the policy to be treated as subsisting with the knowledge of the breach by the assured of warranty, he is said to be or said to have waived his right. It means he is not exercising his right, and you may say that waived his right means insurance company waived its right, but the waiver must be express or complied, but it must be intentional. It must be intentional. So, in this particular session, we discussed on warranties and disclosures, how warranty is important, how warranty is different from representation, what are the special characteristics of warranty, what are the kinds of warranty, and how this warranty means warranty under insurance law is different from warranty under Sale of Goods Act. So, these are all very important aspects you should know, and especially case laws in which these principles are upheld. So, these are the very important aspects you should remember. Thank you.